My dear respected lecturer, today my presentation will be on equity and trust, and this is part 2 of the exam's requirements. The topic for today's discussion is to analyze the general duties of trustees while applying relevant case law throughout this discussion. My presentation format for today would be an introduction, definition of trust, concept of trust, elements of trust, parties to a trust, and my main focus will be on the duties of the trustees. I'll give an overview of the duties, and then I'll go into detailed explanation, and then this will be followed by the summary, thanks and appreciation, and my bibliography. Some writers generally would have the duties of trustees in a number of major headings, and then they would have subheadings, while others would have a broader approach and they would just go on and they would just list them 1, 2, 3, 4 until the end of the duties. You find the definition of trust is a very interesting concept in which the real owner of the property, he reposes or deposits his property for its management or usage in other person for the benefit of a third person. According to Bacon, the trust is a binding. The trust is the binding of the conscience of one to the intention of another. So I am binding your conscience to take care of my property for my kids. So trust in reality is an obligation annexed to the ownership of property. In other words, if you don't have chattel or properties, there's no need to create a trust. So you need to have the trust properties or valuables when you are actually making this annexation. And today's topic will be covering the sections of 3 to 7, mainly on the Trust Act of 1882. Also, we look at the 2000 Act. And the trust concept, by origin, many writers says that the trust concept was an exclusive product of the non-defunct Court of Chancery, which was my very first picture I had on the first slide. And but since the Judicature Act of 1873 and 1875, the trust may be enforced in any court of law. So basically, initially, these trusts used to be taken to the courts of the Chancery, where the people will go and petition the king, as in relation to the first picture I had on the first slide. However, you find that trust has developed so much today that this is enforced in any court of law. The definition, according to Thomas and Hudson's, is the essence of a trust is the imposition of an equitable obligation on a person who is the legal owner of a property. So basically, that's the trustee, which requires that person to act in good conscience when dealing with that property in favor of another person, which is the beneficiary, who has a beneficial interest recognized by equity in the property. The trustee is therefore someone who holds the property on trust. So I give you my property at 27 Bishop Street, then you have to hold this on equity for my inheritors. We find that there are 4 significant elements coming out of this definition. One is to have equitable benefits. So like I said, if there's no property, there'll be no trust. As long as there's a property, there will be equitable benefits from there. It will provide the beneficiary rights to the property. It imposes obligation on the trustee, and those obligations are fiduciary in nature, meaning they are a special bond between you and those who you have to give this trust to. Parties of a trust, we find that the trust enumerates the following parties. The person who reposes and declares the confidence is called the settlor or the author of the trust. For example, I am given my property, therefore I am given that confidence. I am the settlor. Who am I giving it to? I'm giving it to a trustee, which is you. Maybe my lecturer. The person who accepts this confidence is called the trustee. So I'm the settlor. I give it to my lecturer, and she will take care of this trust, and then she will give it to my children. So they are the beneficiaries. So the trust enumerates those following parties: the settlor, the trustee, and the beneficiary. Elements of a valid express trust. Now, before this can hold up some weight in the courts, According to the rule of three certainties in the case of Knight and Knight in 1840, Lord Lansdale has introduced the rule of three certainties, and that will be the certainty of intention, the certainty of subject matter, the certainty of the object. So according to this case, it shows the importance of me. I gave my property truly to my lecturer. She then gives it to my kids. So those are the three certainties. In addition to those certainties, we find formation and constitution plays a very important role. These five principles that binds a valid express trust. Now I want to focus on the duties of trustees, as this is my assignment in today's lecture, today's presentation. An overview would be to act. The duties of the trustees would be to act in good faith, to act in for third parties, duties to familiarize themselves with the trust instrument, to exercise their discretion and consider their powers, to take care when dealing with the trust property, duty of care in investing the trust property, to take professional advice when required, to avoid conflict of interest, to avoid dealing with the trust properties on their own account, to act without remuneration except as allowed by the trust instrument or by law. Trustees is obliged to act impartially as between beneficiaries, to consider relevant matters and disregard irrelevant matters when making decisions, and finally to provide information and accountability to the beneficiaries, or to produce accounts or receipts or documentations when required to do so. Now we're looking at in a more detailed manner. That was the overview, and now the rest of the time I will spend looking at the as much detail as I can, because I find when putting this lecture with this research together, it was so full of juice and energy. I kind of really enjoyed it. There were so many books on the topic, this endless online resources you have. So I kind of spend more than 20 hours, and I have 20 minutes to actually summarize my 20 hours of research into this topic. So to act in good faith, in other words, the trustees are required to act in good conscience and without dishonesty at the most basic level. We find in the case of Odyssey and Entertainment, Odyssey Entertainment Limited and Chem 2012, the claimant's primary claims are against Mr. Ralph Kemp. He was the first defender. And basically, he was a former director and employee but because of breaches of statutory and fiduciary duties of the obligations under a written employment contract. So he did not act in good faith. Acting for third parties, obviously, you can act for third parties and you can act for more than one person, according to Hilton and Baker Booth in 2005, circumstances where a fiduciary may act on behalf of more than one fiduciary, more than one party. So I left my trust to my lecturer for my 5 kids. She is allowed to act for those 5 kids. And we see this in the case, more clarity was seen in this in the case of Kellyanne Cooper, where the defendant estate failed to inform plaintiffs. So there was a bit of failure on the terms of communication. And although the purchaser interests in acquiring both properties were material into the information which could have affected negotiation for the sale, you find the defense were not in breach. So Kellyanne Cooper, actually, they acted for more than one parties in this case, and the court had no problem in this because there was no conflict of interest. The other duty is to familiarize themselves with the trust instrument. I gave my lecturer. It is incumbent on her now to kind of make some inquiries, find out how to dispose of this trust, find out the legal ramifications and the negligence. So you just don't sit there and say, yes, we'll deal with that later. No. It is a duty to familiarize yourself with the trust instrument. Have a look, see what the trustees, see what you're required to do, because once you accept this, you are bound to follow these rules in the equity laws. Obligation and nature of the property involved, you should know. You shouldn't say, okay, the property is somewhere in BD, God knows. This doesn't work like this. You need to identify the property and make sure you see the people who are involved, the range of objects, and the contemplation of the trust. You identify the trustees and the documentations, the people who are involved. And we see this in Clogue and Bond in 1832, and then we see this was emphasized again in Hollows and Lloyd in 1888, where a trustee cannot just sit there without investigating the nature and the extent of this obligation as a trustee. So therefore, before a trustee, it's okay. After you become a trustee, it is incumbent, and the trustee will be liable for any matters of which he or she could be expected to have knowledge about this. Duty to familiarize themselves with the trust instrument. This is a this is basically, we've seen in Daniel and the rest, and the wills and the wills and the law report here in 2018, number 173. It says the claimant subsequently sought compensation from the